Hi again, Attorney Steve Vondran here. We are talking default judgments in Arizona, okay? We've had other videos in our series talking about what a complaint is, talking about what an answer is, when your response is due. We've had those kinds of things. This video is specific to the state of Arizona in Maricopa County, what happens when you're in Superior Court and you file a lawsuit. Let's go up to the Attorney Steve whiteboard here. You file a lawsuit, right? There's your lawsuit. You put an L there. You get your summons served, right? The court issues the summons. The summons is the document that commands the defendant to come into court and answer within their stated time frames, okay? If they're not answering within the time frame, then you have a right to go seek their default, okay? Or what we call take the default. We'll call that D for default, okay? We've talked about in other videos how in Arizona it's normally 20 days when you're suing a in-state defendant, and in California it's 30 days, but this video is on California. We're licensed to practice law in California and Arizona, and we help business and real estate clients in both states. So you have in Arizona the 20 days to respond. If you're suing an out-of-state defendant in Arizona, they're going to get 30 days to respond, okay? So bear that in mind. There could be other special rules for service of process, but these are the ones I want you to bear in mind. These are the ones we normally see. So in Arizona, if they don't answer within the 20 days, you have the right to go take their default. That's what we're talking about here, okay? Now, basically with the default, you're going to be filing a default package, okay? In Arizona, we use the turbo court filing, okay, the easy turbo. And so your case was initiated online. You filed your lawsuit, and you end up getting a case online, and now they're not responding. So you need to go into your turbo. You need to fill out a default package, which is your application for your default. You fill that out. You basically submit it into the turbo with your proof of services. Remember, after you serve the defendant here, somebody should have filed a proof of service with the court, POS, proof of service with the court. So all you're doing is filing the application, attaching those proofs of service and letting the court know, this is when I sued them, they didn't answer, they were served, here's my affidavits that they were served, and you're submitting that in. And then after you submit this, you're going to get a printout, and you're going to take that printout in and get it filed, okay? You're going to go over the counter and get it filed. So that's what we're talking about in a default. Now, a question that often arises is, if I file this default here, does that mean that I win, that the case is over, that they can't answer, that they're locked out? No, unfortunately in Arizona that's not the rule. In Arizona we have Rule 55, okay, Rule 55, and that's Arizona Rules of Civil Procedure, and that talks about once you file for that default and you've got that default entered into court, the other party, the defendant, still has 10 working days to come back in and file their response. And in our other video, we talked about the types of different responses that you would see. Normally in Arizona, a motion to dismiss or an answer with affirmative defenses, okay? Motion to dismiss, answer with affirmative defenses. That's normally, you're gonna see one or the other. And sometimes you'll see the motion to dismiss, you'll fight that out a little bit, and then the court will eventually make them answer. Okay, so you could have either one of those, and that's really, those are the things where you need to have an attorney advise you what do you need to do, okay? Because sometimes you waste your money doing a motion to dismiss when you know they state a good cause of action. You're going to waste money on a motion to dismiss and an appearance and all that stuff. So, but realize in Arizona, the Rule 55 says you have 10 days as a defendant. You still get, in addition to your 20, you still have another 10 days to get in there and lodge an answer or a response, okay? So that's pretty much how it works. That's your default judgment in Arizona. When you're done, if they don't answer within the 10 days, you'll get your judgment, realizing the judge has the right to set up what we call a prove-up hearing, and that's where you have to come in and actually prove your damages and show the judge why you are entitled to damages. We have another video about burden of proof. Type in Attorney Steve burden of proof. and we'll talk about the different burdens of proof that may apply to your case. Okay, so that's in general. There's your complaint, your service, failure to respond within a timely manner, submitting for your default, proving it up if you have to, and there's your general guidelines for that. Okay, we have a blog on vondranlaw.com. That's vondranlaw.com. that has a link to get this handy little application here, so you can get that filled out and get that submitted. Okay, who's looking out for you? Attorney Steve's looking out for you. That's who. So give us a call if you're in a business or real estate litigation and arbitration and mediation. You need some legal assistance. Give us a call, 877-276-5084, or shoot us an email at attorneysteve.net. That's law@attorneysteve.net. We thank you so much for your time. We hope this has been helpful. As always, thank you for supporting and following us. And don't forget, give me that coveted thumbs up on YouTube. Give me that coveted thumbs up. Come on now. All right, y'all. Have a great day. We'll talk to you again.